So today we are taking up this topic of Decoding Data Protection Bill 2022. This is a long-awaited revolution or a path-breaking law because India, as you know, we have so many people, so many cultures, so many corporates, and we are emerging as one of the fastest growing economies of the world. That means we are also full of data, whether personal data, corporate data. The world is eyeing us, the world is eyeing our data. So while we go global, it is also very, very important and pertinent to take care of national and individual interest. So today we are trying to contribute some way in sharing the thoughts, insights about this law. So today this topic will be taken care of by Ms. Khyati Dhupar. I'll just give a quick introduction of Khyati to all of you. Harsh, may I request you please change the slide. Khyati is a managing partner of Dhupar and Associates. She's a member of, she did her LLM from Queen Mary University, London, and is a member of Bar Council of Delhi, High Court of Delhi, few international bar associations, including the International Bar Association of London. So while she's practicing in India, but she has a great proficiency for the laws of the world. We have personally experienced that her over our various professional engagements. Some of the companies that she have advised on includes NIIT, Millman, World Bank, MCX, Sony Pictures. So we welcome Khyati to this session. Khyati, are you there? I hope you are. We are audible to you.
Hi, thank you, Gaurav. Thank you. Sorry, I was facing little tech issue here.
Perfectly fine.
Yes. Thank you so much, Gaurav, and thank you, Harsh, and thank you everyone for coming here today for attending this webinar. And we'll quickly start with this webinar. I'll not take much of your time because I know all of you are really interested to know more about this particular bill and how it evolved and what it covers and what are the compliances. So we'll just quickly start.
Sure. Khyati, we'll just take a minute of more. So I'll just quickly introduce also our organization Lex Comply to our audience. So as Lex Comply, we have been primarily working on improving the compliance and governance structures of any organization by some of our innovative applications, which is compliance management and contract management. So we help the organization to know their applicable laws and compliances basis the business they are into, not only for India, but we have served more than 24 global geographies till now. We also have a product with the name Lex Buddy, which is like Google of compliances, wherein you can search on Indian laws. You can search the laws basis your own company. You can search the basis the law. You can all get the checklist of the compliances. You get the forms of the compliances and the legal updates. It is our endeavor to put forward to you or share the knowledge with you with the new topics coming in. So I'll just now request Khyati to take over this session, and my colleague Harsh will navigate her presentation. Harsh, over to you.
Thank you, Harsh. I see some people are still facing issues. Can everyone hear us? Am I audible?
Members who are not able to hear us are requested, or having any other issues, requested to please put that on the chat box. We'll respond to your queries. And if they're not able to hear us, we just request them to have a re-login, please. Sunilji, Trishla, thank you. We have just got some confirmation that audio is clear. So we move on with the session, and we have some people raising their hands. So request you to please send on the chat. We will have a Q&A sessions at the end of the thing, and there will also be certificates which will be issued subsequent to this session. And we are here to, we'll be quickly responding to all your queries on the chat box as well, with respect if you are facing any technical issues. Thank you. Khyati, over to you, please.
Yes, thank you. Thank you. Right. So I hope everyone can hear me, see me, and look at the presentation. We'll start quickly. Today, we are decoding the data protection bill and how it's evolved into what it is today, and what does the future look like with this bill. Harsh, we can move to the next slide. Yes. So today, basically, we'll be covering 4 major agendas in this webinar. Firstly, I'll give you a history or the introduction to the bill and its nature, how it's evolved. Then we'll talk about how this bill is different from the one that was introduced back in 2019, your Personal Data Protection Bill of 2019. The one today is called the Digital Personal Data Protection Bill 2022. We'll discuss the perspective on the bills, and then we'll move on to the key terms, which includes your data principal, data fiduciary, what is the data protection board mean, what is the cross-border data transfer, what are the penalties and exemptions under this new bill. And then finally, we'll come and talk about the impacts and the compliance, the road to the compliance and the potential impact that's going to be on all industries. Right. So back in 2017, the central government decided that, there was a lot of hue and cry about personal data protection, a lot of misuse of the data. So back in 2017, the central government constituted a Justice B.N. Sai Krishna committee, which was headed by Justice B.N. Sri Krishna, who's the ex-Supreme Court judge. And he headed this committee, and after a lot of deliberations, they prepared a report which came to a conclusion that personal data needs to be processed in a certain manner. It needs to be taken care of in a certain manner in India. By then, there was a lot of talks of GDPR and privacy and data protection all over the world. So this is when India also thought that we need to have stringent provisions with respect to it. We need to see where the privacy of the people is getting violated, what can be done to protect it. Around the same time, around August 2017, the Supreme Court passed an order in a landmark judgment in Justice K.N. Puttaswamy versus Union of India, where they said that your right to privacy, your personal data includes your right to privacy. So your right to privacy means your right to privacy on your personal data. Although they did not define what is your personal data, what is your personal sensitive data, although that has been done in your various IT rules in the past. But the Supreme Court or the committee, the Sri Krishna committee, was not clear on these terms. But they said that, Aadhaar became a very important document of discussion. The right to privacy became a very important point of discussion. That is when finally in 2019, a bill, the Personal Data Protection Bill, was introduced in Lok Sabha. This bill came out after a lot of deliberations. This was presented in Lok Sabha, and by the central government. And this bill spoke about what your personal data is. They spoke about your personal sensitive data, something like your name, your address, your phone number, your contact details. Then they spoke about, this bill also spoke about how we are going to protect it, when it can be shared, who it can be shared with, whether a consent is required by the person who's sharing your data, who's sharing their own data. What is the compliance that entities who are collecting the data required to do? So that became very important point of discussion, and which is why this bill was introduced. But we realized that there was a lot of flaws. So government asked a lot of stakeholders to send in their recommendations, and there were a number of recommendations that came in, and we realized that, and the government realized, in fact, that there were a lot of loopholes. A lot of recommendations went from lawyers. Even my office sent a recommendation back in the day. And there were a number of loopholes, and there were a number of issues that we realized were needed to be discussed or covered in this Personal Data Protection Bill. Which is why back in 2022, August 2022, this Personal Data Protection Bill of 2019 was withdrawn. And in November 2022, a new bill was introduced, which is your Digital Personal Data Protection Bill. Okay. So that's how the law evolved. That's how this bill came into being, of what it is. And we'll now see what the present bill talks about. Harsh, we can move to the next slide. Thank you. So the key significance of this new bill, the Digital Personal Data Protection Bill, it talks about, amongst the other things that it talks about, there are three things which are very, very different from your previous bill and which are very important or significant aspects of this bill. One, that there were concessions given on cross-border data flows, because we know that a lot of entities, a lot of MNCs are storing their data overseas. They're sharing their data with foreign entities, which needed to be regulated, which needed to follow a particular compliance in the country, although those countries were following GDPR and their local privacy and data protection laws. But there was there was a need that Indian laws also control how this data is being transferred from India to overseas, how it's being maintained in India, who all it can be transferred to overseas. So this became one of the very significant aspect of the bill. Then another point is that this bill also gave a perspective on data localization requirements. It also took, although there were in the previous bill there were stringent ways to store data internally in the country, but this bill has smoothened it out because they realized that it's not possible for smaller entities to have a very robust compliance system or a robust system to maintain that data in India. So this became another significant aspect of this bill. And of course, the right to postmortem privacy, which is your right to withdraw your consent of using your data. So unlike the previous bill, this bill gave a new right to the data providers, somebody like you and me who are sharing our data with companies day in, day out. If in future we want to stop them to share or store our data, we can withdraw our consent. So this is another significant aspect of the bill. We can move to the next phase. Yes, the highlights of the bill. So this bill, unlike your previous version, this bill the scope is actually limited to personal data which is either collected online or personal data which is collected offline but digitized. For example, whenever we visit a bank, we share these lengthy forms, we fill in our names, details, whatever, and they go onto the bank server. So even though we are filling a paper form, but if that information is getting digitized, it comes under the purview of this present scenario bill. Also, the data that we fill online, I'm sure all of you filled in a tiny form before attending this webinar. So that also is covered under the purview of this bill. However, anything that you're filing physically on paper, wherever you're sharing any data physically, for example, if you're entering a building and a guard asks you to fill in your personal details at the entry in a register, but that is not getting digitized, this bill will not cover it. This bill only covers whatever is collected online or whatever is collected offline and then digitized. Okay. Yes, I think somebody is raising a hand.
Kathy, you may please continue. We are taking care of that.
Okay, all right. Thank you. All right. Next is the duties of the data principal. So this bill also protects the rights of the data principal, the people who are sharing their own data, people like you and me who are sharing their data. And of course, this has imposed penalties up to 10,000 rupees on a breach by the data fiduciary. Then another highlight of the bill is your voluntary undertaking. So this bill also allows undertakings voluntarily by entities who are not able to fulfill the compliance, but they can, just fill a form or an undertaking and inform the government or the respective board or the authority under this act that we are not able to fulfill the compliance for whatever XYZ reasons. And we would request you to grant us an extension or an additional time so that these entities can avoid penalties. Otherwise, breach of data protection is liable to heavy penalties. In fact, in the previous bill, it was even liable for criminal penalties like imprisonment. However, this bill evolved and the government realized that imposing criminal penalties on data breach is way too stringent a punishment, which is why only a financial punishment is now applicable under this new bill. Also, this bill mandates that the request or the notice given by the data principal or any data which is stored, before storing that data fiduciary is required to give to seek a consent from the data principal whether they can store the data, and accordingly they have to give that notice. That notice needn't only be given in English but can also be given in other 22 vernacular languages which are included in the 8th schedule in the Constitution of India. So that means that people will not have to blindly sign a document without even realizing that they're permitting the entities to use their data, because they probably don't understand the language it's written in, which is why it says that these notices and these consents must be given out in 23 languages, including English. So that includes all your regional languages, which is your Kannada, Telugu, Tamil, Bengali, Gujarati, Marathi, and amongst and the others. Okay, another highlight of the bill is that, as I mentioned, that this bill does not have any criminal penalty for non-compliance. The penalties, however, have gone up to 500 crores of rupees, for instance, whenever there is a breach. So, I mean, there are heavy penalties which are imposed under this law, but of course, no criminal penalty. And of course, exemptions are granted under this law. These exemptions are granted to the people who are collecting data, the data fiduciaries who are collecting data and processing data. But these exemptions are granted on the basis of how big that entity is, what is the volume of personal data which is being processed, what is the number of users that there are, which is why there was a need for a voluntary undertaking that smaller entities who are maybe just collecting small amount of data for day-to-day day-to-day business, or maybe just collecting their client data, they can just sign a voluntary undertaking and let the concerned authority know that if they have not complied with, at least they have the intention to, or maybe they're exempted under this law to not comply. We can move to the next slide, please. Right. So, when you read the Digital Data Protection Bill of 2022, you realize that the purpose of this act was to ensure that digital personal data is managed in a certain manner, it is made secure in a certain manner, and it is only used for lawful purposes. Like I mentioned earlier, this only covers your digital personal data, not your hard copy, not your paper data, but your data which is collected either online or data which is collected offline but digitized. So that's the purpose of the bill. Right. Now coming to how this 2022 bill is different from the 2019 bill. I've already given you bits and pieces of information that the 2019 bill had some loopholes, was very stringent when it came to penalties. There were some things, there were some points in some, sections of this bill which required more clarity. For example, when we talk about the scope and the applicability, the previous bill only spoke about personal data which was collected and disclosed within the territory of India, and not, with respect to services which are sought outside India. However, the 2022 Act covers processing wherever data is collected for processing or stored within India, irrespective of where it's gathered from, whether it's offline, online. So if some of you are watching this webinar from overseas and you filled in that tiny form wherein you shared your personal data, your contact details, that means because this webinar is being conducted by an Indian entity, the processing of this data is done in India, this new bill would be applicable on us, on the entity that has collected your data, even if you're sitting outside. Then, this 2022 data also talks about, what are the lawful basis of processing. When we spoke about the 2019 bill, the 2019 bill had a lot of cumbersome, compliances that when data can be processed. You had to get consent from the individuals. There were some legal obligations. There were some, vital interests that you had to take care of, so on and so forth. However, this new bill has simplified the law basis of processing, that either you get consent from the data principal or you get a deemed consent wherever the data principal himself or herself is not in capacity to give their own consent and may be given through somebody. So it's a deemed consent. For example, in case of children, when children, because children are not able to give their own consent, so their parents can give that consent on their behalf or their legal guardian, and that can be deemed as their consent. So this has simplified the lawful basis of processing. Also, when talking about consent, the previous bill only said that there had to be, so previous bill, like I said, had a lot of flaws, and previous bill said that for consent, it should be very clear, it should be specific, it should be informed. However, the 2022 bill has clarified and simplified the term. They said that, we don't need a very stringent consent. It doesn't really need to be a form that needs to be signed. It can be just click of a button that says, that little click that you make while signing any agreement or, before attending this webinar. It could just be that you've read it, you accept that you're okay with sharing your data, and that would be covered here. So your explicit consent and a deemed consent or your consent would be covered here. Okay, now coming to registration. So under the previous bill, the significant data fiduciaries were required to register with themselves with the Data Protection Authority. However, this new bill has changed the details and the structure and the name of the authority. Now it's the Data Protection Board. So the central government under this bill is going to establish a board, which is going to have technical members, which is going to have some members probably from the judiciary, who are going to decide issues whenever there's going to be a data breach. And of course, the consent manager is required to register themselves with the Data Protection Board. So the consent manager of that particular data fiduciary organization would be required to register themselves with the board. And once you've registered, you would be required to take care of your regular compliances. So it seems like it could be something similar to getting a registration or an enrollment with the board. And then, of course, then there's going to be regular compliance and intimation to the board. And if there is any breach by you, then people whosoever's data has been breached or whosoever has suffered because of that breach would reach out to the Data Protection Board, file a complaint. And this would, it seems like that this would work like a quasi-judicial body, something like a mix of a tribunal and a regulatory authority. Then next is appointment of a data protection manager. So under the new bill, it is mandatory for significant data fiduciaries, the data fiduciaries who are storing the data, who are processing the data, who are using the data for legal purposes. It is mandatory for them to have a data protection officer in their organization who is going to take care of the legal ways how this data is used and sorted. Next slide, please. Right. Then with respect to the breach notification, previously, in the previous bill, in the 2019 bill, the data fiduciary was required to intimate the authority as soon as there was a data breach and of course publish it on their website. And in the new bill, the data fiduciary or the data processor has to inform to the Data Protection Board, and they have to also inform individually to each data principal that there's been a data breach and that your data has leaked for whatever whenever a breach happens. So instead of just notifying on your website, the data fiduciary's responsibility has increased under the new bill, that they would have to reach out to the data principal or the person who's giving their data and inform them that there has been this breach. Then the next difference is with respect to data subject rights. In the 2019 bill, there was a right to access, right to data portability, right to correct the information, and right to be forgotten. However, in the new bill, of course, these rights exist, but there is also a right to obtain information, that you as a data principal who's given your information, you can even inquire from the data fiduciary who you've provided your personal data to, whether they are still retaining your document, whether they still have access to it. You can even ask them to provide you the information at a later date, whichever when you need that information, what was provided by you. For example, you go to a bank and for KYC purposes, you've given a copy of your Aadhaar and PAN. God forbid you lose that document and you don't have that available with you. So you can reach out to the data fiduciary, which is your bank today, and you can ask them for the copy of the information that you have provided. So you can seek that. Of course, then there is the right to correction and right to forget. That means if there is a mistake on the data provided by you, there is a typographical error or some whatsoever error, there is some mistake, maybe your date of birth is incorrect or maybe your contact details are incorrect, then that can be rectified. And also the right to forget, which I mentioned earlier also, that you can withdraw your consent for your data to be stored and processed by the entity. So today, maybe for some purpose, we have shared our data with the data fiduciary, but tomorrow I feel that, you know, my data is not safe or I don't want to keep it with that entity, as simple as that. I can withdraw my consent and get my data back. And of course, there's a right to grievance redressal. Under the new bill, you can approach the data protection board, you can file a complaint there. And there is also, as a data principal, you also have the right to nominate somebody who's going to give your consent on your behalf. For example, I said where somebody is incapacitated or minors or somebody of unsound mind, where they cannot give their own consent, they can nominate somebody who is going to give their consent on their behalf, which is going to be the deemed consent. Okay. Next, with respect to cross-border data transfer, which is super, super important because crazy amount of data flows in and out of this country all the time, especially now with the, you know, everyone having their servers overseas. So there's a lot of personal sensitive data which is being stored outside India and which needed to be regulated by way of this bill. 2019 bill, mentioned, it actually spoke about the sensitive personal data which was stored in India, but may be transferred to overseas, but it did not speak much in detail. However, now with the new bill, the government has simplified it and said that if you're collecting any data, let's say in India, in the territory of India, and you're going to have that cross-border data transfer, you will only do that with those countries, with those entities, with those countries which are notified by the central government, where they have very stringent and very good data protection laws, so that your data is not misused and nothing bad happens to you in the country. It's not misused by anybody overseas. So with respect to cross-border data transfer, of course things have been simplified under the new bill, but the government has also put a restriction to it that you're not going to send it to the countries. For example, there's some African countries which use your data, misuse your data, in fact. So there's going to be, of course, the government has not come out with that list as of yet, but we are hopeful that some of those countries would be banned. You won't be allowed to share your cross-border data with those countries. And if you have to for whatever XYZ reason, probably you'll have to seek that consent from the central government. But sharing your data with countries like Europe and US, which have very strong data protection laws, it would be much easier, because definitely once the central government notifies the list of countries where you can transfer your personal data to, these countries that have stringent data protection laws, they would be covered. And of course, that would work in reciprocity with them. So that means not only data going out from India, but also data coming into India. Okay, now with respect to the penalties, the difference with respect to the penalties, back in 2019 bill, like I mentioned, there were criminal liabilities, there was criminal imprisonment up to 3 years in case of breach. The penalties were up to 15 crore rupees or 4% of the group annual turnover. But the new bill has amended all of that. Now, if there is a penalty on the data principle, that means people like you and me who are sharing our data, then the penalty is up to 10,000 rupees. The criminal penalty has been scraped off. So there's no criminal penalty under the new bill. And of course, if there is a breach or, an offense under this data protection bill by a data fiduciary, then the penalties can go up to 500 crore rupees. So that's a heavy penalty under the new act, heavy financial penalties. Right. So with respect to the, now coming to the perspective on the bill, this bill, as I mentioned, the applicability of this bill is only limited to online or offline data, which is digitized and then stored in India or processed in India. This particular bill would not apply to individuals. There are a number of exemptions. It's not going to apply on, of course, the exemptions are also granted to government entities or in cases where data is used for national security purposes. So that's one of the applicabilities of, that's the limit of the applicability of the bill. Then this bill does not differentiate between personal and sensitive personal data. It just safeguards all your personal data, whether sensitive or insensitive, something like your name and your address. It may not be sensitive data, but your personal sensitive data and your non-sensitive data are looked at similarly under this particular bill. There is no differentiation. Storing and safeguarding your information, whether sensitive or not sensitive, are both very, very important and would be taken care of under this bill equally. Then coming to the privacy notice. Okay, so now under this bill, there are some privacy. So before a data principal, people like you and me, we share our data with the data fiduciary. We have to give a consent, right? After giving the consent, at the time of giving the consent, the data fiduciary has to give us a notice of informing us that they are going to store this information, retain it, they're going to process it. However, they cannot transfer this data to somebody else until and unless there is a specific notice with respect to that and I consent to it. That means the data principal consents to it. This data cannot be transferred. That means that under this bill, any information that you share will remain private and will be retained. And of course, this is going to have retrospective application. So once the bill comes into place, then only it would be applicable. So whatever's happened, so then it would be applicable, but whatever data has already been stored or retained, all those organizations, all those data fiduciaries would have to comply with the provisions of this bill, even though this data was collected prior to the enactment of the act. So it has a retrospective application. Then non-automated means, that means that this bill would not, another perspective, so basically this bill would not apply to anything that is retained, that is collected, and that is stored offline on a piece of paper. I gave you an example of, security guard asking you to fill in your details at the, in a register at the gates of any building. So that would not be covered under this particular bill. So if there is a misuse of data from that area, from that register, unfortunately, that would not be covered here. We won't be able to do anything about it, that there's been a misuse of data, that somebody's gotten your address or mobile number from there and misused it. So unfortunately, that is not part of this particular bill. Moving on to the next slide, please. Yes. Now, breach notification. As I already mentioned earlier, that unlike the previous bill, under the 2022 bill, whenever there's going to be a breach, there is an obligation on the data fiduciary or the processor, the person who's or the entity who's processing the data, to inform the data principals that there has been a data breach and your information has been hacked or whatever, and there is a risk to the information. So, and you have to also inform, and as a data fiduciary, the liability is also on them to inform the severity of the risk, that how big the data breach has been, what all has been breached. So all that has to be informed to the data principal instead of just putting a notice on their website. Now, with respect to the privacy and default, privacy by design and default. So this bill does not contain provisions with respect to privacy by design and default. Basically, what it's doing is it's taking an approach where data fiduciaries, of course, they're retaining your information, they're processing it, but there is no restriction on I mean, of course, there's restriction on how they are not going to transfer this information without consent, but there are going to be issues because sometimes there are going to be issues because at the time of giving your consent, you don't read whether this transfer of data is permitted or not. And if at the time of giving consent, you've given a consent that the data transfer can be permitted, then that data can be permitted, can be transferred from the data fiduciary to any other organization. Although, that still remains a point of discussion before the government, because, at one point, you are asking people to give their consent and you're giving a notice as a data fiduciary that you are not going to misuse this data, you're not going to transfer it to somebody else. But on the other hand, you are granting an exemption. You're saying as long as the notice by the data fiduciary says that they can transfer this information to somebody else, then they're permitted to transfer. So there seems to be a little bit of a contradiction with respect to privacies under this data protection bill, especially when a consent is sought at the time of issuing notice. Okay, moving on. Then with respect to personal data of children, there are very stringent provisions under this bill. So this bill actually prohibits trafficking and prohibit and stop trafficking, human trafficking, targeting children. This prohibits tracking of behavioral monitoring of children. So basically, no data can be tracked of children. Their ads cannot be tracked. In fact, no target advertisements can be done towards them. No, no monitoring of data can be done towards them. So basically, they're trying to protect children under this bill. And of course, wherever children's data is being sought, consent needs to be sought from their parents or their guardians, as the case may be. Then implementation timeline of this bill. Unfortunately, the government has not given a timeline as to once the bill becomes an act, how much time would be given to organizations to start implementing. Of course, they're going to start at a slow and steady pace. So it seems like that the organizations, the data fiduciaries are going to get sufficient time to comply themselves with under the bill. However, no timeline is mentioned that within 6 months or within a year you have to comply with this bill as of now. Right. Now coming to the key terms. I've been going on and on about data principal, data fiduciary, but probably some of you are still confused as to who is data principal, who's data fiduciary, what is the data protection board, so on and so forth. So now we're going to discuss these key terms. Now, who is a data principal? Next slide, please. Right, who is a data principal? Data principal is a person, an individual whose data is being collected. Data principal would also cover children. However, in case of children, like I mentioned, their consent has to be given by their parents and lawful guardians. But a person whose data is being collected, whose data is being retained, whose data is being stored, whose data is being processed, these individuals would become, or maybe a company's data would also become the data principal. So if I'm filling up, if before the webinar, since you guys filled up the form, you guys are data principal for this purpose. However, who is the data fiduciary? Data fiduciary is an entity. It could be an individual, it could be a state, it could be a company who retains, who collects the information from the data principal, who retains this information, who uses this for processing or processes it, the individual's personal data. So, like I mentioned, data principal is the person who's giving the information, and data fiduciary is the person who's collecting the information in simple terms. Moving on to the next slide, please. Right. What are the rights of the data principal? So since you and I, we are giving our consent to another entity, to a data fiduciary, what are our rights as data principal? So our first right is the right to grievance redressal. Of course, wherever there is a breach or there is a misuse of your data, you can approach the board under this bill, and you can seek your grievance redressal there. Of course, the first point of contact, you would reach out to the data fiduciary and you would inform them of the grievance, whatever you have. Maybe your data is incorrect, you want to fix that, you want to seek, or maybe you want to seek your consent back, you want to withdraw your consent, or maybe there's been a breach and you just want to make a complaint against, or there's been a misuse of data, maybe you want to make a complaint against the data fiduciary. So the right to grievance redressal is given to the data principal. That's one of the rights. Next is right to data portability. The bill does not provide the right to data portability to data principal. However, data portability, I'm sorry, like I mentioned, the bill does not allow the right to portability to data principal. That means you and we cannot transfer our data to somebody else. I mean, if we've given our data, let's say, to a data fiduciary X, we can't ask that data fiduciary X to transfer our data to a Y entity when we want it, right? If X and Y have an agreement on a data transfer to which I have already consented, that is a different story altogether. But for example, I can't, ask my personal sensitive data. For example, I can't ask my bank to share my KYC documents with some other organization where I'm supposed to provide it. So what I can do instead is I can ask them to give me that information and provide it on my own, but I can't ask them to forward my information to another entity or some other, company or an individual. Then another point is, another right of the data principal is the right to access. So you have the right as a data principal to access your own information. You can reach out to the data fiduciary who's collected your data, or who's processing your data, who's stored your data, who's retained your data, to provide you with the information that you have provided. Like I mentioned, that if you have provided your details, you've provided copy of your Aadhaar or PAN card for KYC purposes to a bank, and you lose it, so you can ask them to give that information back to you. So you have the right to access whatever information you have provided. Sometimes you click so many consents online, you don't even realize that who all has your personal sensitive data. So you can even track those, and you can ask those organizations and entities what kind of data they are retaining. You can ask them to give you the access to your information which they have retained, and later on maybe you can just withdraw that consent. Then another right you have as a data principal is the right to nominate. So like I mentioned, in case of children, minor, people who are incapacitated, people who are of unsound mind, they can nominate somebody who can who can give the consent on their behalf. So they can nominate another individual who's going to behave like a data principal for such people. Also, in case of death, so what happens when we die and what happens to our data then? Then we can also nominate somebody else who's going to handle that data after my death, who can take care of it, whether they want to still store that data or they want to withdraw on my behalf when I'm no more. So these are few of the rights of the data principals. Right, now coming to the Data Protection Board. Like I mentioned, under the Act, this authority, a quasi-judicial body, would be created called the Data Protection Board. It would be established and notified by the central government. It would constitute of technical experts who are going to, check how, companies are complying with the provisions of this law. Like I mentioned, that the data processing officer of the company is going to register with the Data Protection Board. So Data Protection Board is also going to take care of, the registrations. They're going to monitor the compliances, and they're also going to provide complaint redressal to individuals and the complainants. So in case of data breach or data misuse, the complainants are going to approach the Data Protection Board, and Data Protection Board is going to work like a quasi-judicial body or a tribunal, and they would provide relief to the complainants. As I already mentioned, the functions of the board include monitoring of compliances, imposing penalties, directing data fiduciaries to take necessary actions in case of data breach, hearing grievances of individuals, ensuring that the registrations are done by data fiduciaries, ensuring that the compliance is taken care of by data fiduciaries, and of course, imposing penalties. Next slide, please. Okay, coming to cross-border data transfer. So section 17 of this bill talks about cross-border data protection, data transfer. Basically, it says that if any information which is covered under this particular bill is transferred overseas, it can only be transferred to those countries where India has, allowed you to transfer. So the central government, like I mentioned, is going to come out with a list of countries that they're going to allow where data can be shared. And those countries are the ones that have stringent data protection laws. For example, Europe. Everyone knows Europe has a very good GDPR law. So India is going to work on a reciprocity basis with them with respect to data transfer. So we can get their data in India from those countries, and we can send our data to those countries for storage or retaining or processing or whatever purpose it may be. But like I mentioned, that list is still not out. There are going to be a number of countries where data will not be permitted to share, which is why it's easier for government to come out with a list where we can transfer our data to. So countries like Singapore or Europe, it'll be easier for us to transfer data there, and we would not need a prior consent on anything. And but with respect to high risk countries, or maybe countries where there are heavy terrorist organizations running, that's where the government of India is going to put a restriction on, and you won't be allowed to transfer data there. So moving on to the next slide, please. Okay, penalties and exemptions. So as I already mentioned, your penalties under this particular bill do not include any criminal imprisonment penalties. So no criminal penalties. However, they're going to be financial penalties. Financial penalties are going to go up to 500 crores for every breach at every instance. And if there is a breach or an offense by the data principal, then those penalties would go up to 10,000 rupees only. Okay, now exemption. So there are, of course, some exemptions to the applicability of this data protection bill. I already mentioned that, the entities that are much smaller, that do not have high volumes or who are not collecting high number of data would definitely be exempted under this particular bill. Although what that number, how many people, how many employees that entity has, all of that needs to be clarified and defined. Right now, the bill is still silent on it. But from the current perspective, we understand that, of course, some concession would be given to entities which are smaller and are processing or retaining very small data. Again, the exemption is to the offline data, which is not digitized. It is not covered under this the provisions of this bill. Again, data which is gathered or collected for the purpose of national security, again, exemptions would be provided under this bill. So any data which is used for like national security, to protect the integrity of the country, to protect in the interest of sovereignty of the country. So these agencies or these entities who are collecting the data for these purposes would be exempted under this particular bill. So that means a lot of government agencies would be exempted from the compliance under this particular bill. Moving on. Yes. So what is the potential impact we see on the industries? Of course, we see that, all the large scale industries, all consumer centric organizations, your MNCs and your e-commerce and all the other kinds of industries are going to have strict compliance with respect to your personal data which is being collected. Of course, this would increase in giving your consent every day in and out. However, this would also help in protecting your interest as a data principal and protecting your data, because even though these entities who are retaining your data, they would have to comply. And in case there is a breach, of course, there's going to be a heavy penalty on them. So now you can be very sure that your data is not going to get misused. Till now, your data is getting misused. Today, if I have to buy a SIM card, I give in my details or I give my details to the bank. And tomorrow I start getting calls left, right, center from number of agencies. That definitely is going to stop because my data would not be allowed to transfer. My data would not be misused. Of course, to an extent, we are hopeful that due to this data protection and the compliance And because the data transfer is not allowed and there's going to be heavy penalty on organizations, the number of these online frauds where your data has been misused, where people misrepresent and gather your information and act on your behalf, that would definitely reduce to an extent. Also, your data transfer, cross-border data transfer would become much easier. You would a lot of Indian entities would start sharing their data overseas, although they're already doing it, but this would increase or make it easier for the flow of data in and out of the country. And of course, smaller organizations or maybe mid-level organizations or family-run organizations would also start digitizing their data, would start taking care of compliances, would start holding themselves accountable to the provisions of this particular bill. So we see that a lot of things would change, everything would digitize, and of course some privacy would come into place. Unnecessary sharing of your personal data would probably be reduced, if not stopped at all. Right. Road to compliance. So what are industries required to do for compliance under the bill? So there are about 10 to 12 things that these industries who are data fiduciaries, these entities or people who are collecting data, whether online and offline, which is digitized, they would require to take care of certain things in order to protect the interests of the data principle or protect the privacy of the data principle, which is why it is required under this particular bill that a data protection officer, a DPO, be appointed. His or her business contact information be shared or displayed on the website of the entity. It could be shared and displayed with the data principle, so that in case tomorrow there is a breach or there is any concern, that the data principle officer is going to be the first point of contact for any data principle. Of course, the entities would also have to draft a privacy notice. They have to inform the data principal every time they're gathering the data that we are gathering this data for XYZ purpose. We are going to retain it, we are going to store it, we are going to process it in India and or overseas. And we may, and of course, if you want to transfer the data as a data fiduciary, you will have to seek the consent upfront. Otherwise, you're going to mention it that we are not going to share your data with somebody else. Okay, next is that you have to inform data principals about the type of data that you're collecting and the purpose. For example, if you're collecting the data for KYC purposes, you'll have to inform the data principal that the purpose of collecting this data is a KYC purpose and nothing else. Or maybe, we are trying to verify your address and your name and details, that's it. So every time a data is collected, you not only have to give a notice, you also have to inform the data principal as to why you are collecting this information, what is the purpose. Of course, then the data fiduciaries and the entities would have to have their internal privacy policies and procedures as per this bill, and they have to implement it. They have to, respond to the data principal's right requests. If let's say the data principal wants to withdraw their consent and withdraw their data, so these entities would have to entertain those requests and return that data and stop using and processing that data. Of course, the data fiduciaries would also have to have your first point of grievance redressal for data principals, because even before approaching the board, the data principal is first going to address their concerns with the data fiduciary. So these are few things that as a data fiduciary, entities or companies are required to do. They also need to implement strong technical and organizational measures and reasonable security regulations. They have to involve a data processor wherever required and have a valid contract with them. I mean, you can't just left, right, center as a data fiduciary share your data with anybody. You can't send it to any person for data processing. You need to have a valid contract with that entity or another person who's going to be your data processor. And of course, you have to maintain your data personal breach notification template with the board and the data principal. You have to, as a data fiduciary, you have to register yourself with the board. You have to undertake the impact assessment from time to time, so that tomorrow there's no data breaches and there's no misuse of data at your end. Of course, at times also appoint an independent data auditor who is saying how this data is collected, retained, stored, and definitely not misused. And of course, timely perform audits and checks to ensure that the compliance is taken care of and under this bill and its objectives are met. So this was all from me for today with respect to the data protection bill. If you have any questions, please feel free to reach out. Please feel free to address it right now and I'm happy to answer.
Thanks, Khyati. Yes, we first of all, thanks for this very comprehensive session, and I can see a very encouraging response and a lot of queries already lined up. We have almost like 14-15 queries during the session itself, and this shows how serious and how responsible we are as citizens about this data protection subject and about the future of our generations, which are definitely going to be linked with a lot of our data, which is being stored in so many platforms across the board. So, though within my limited knowledge, I've tried to address few of them during the session. But yes, we have some very pertinent questions which can help the other audience. I'm taking it up one by one, and then you can address them, please.
Sure.
So allow me a minute, please. So there is a question from Mr. Pradeep Kumar. He says that I think this can be this is very important, that while we are we are downloading any app or we are trying to use any mobile application or we are buying a mobile, today's lot of applications do not allow us if we do not have a particular email ID. There are folders with them or pictures with them or data capturing over mobile. So does this current bill provides any protection or has any view on this specific problems which are being faced?
Right. So basically under this particular bill, as I mentioned, that every data fiduciary, every entity or a company that is collecting data would have to give you a notice first as to why they're collecting this data, how they're going to retain it, what is the purpose, where they're going to retain it. So every time you're going to download a mobile application, it asks you to share your personal data, like your email ID, your name, your phone number. There would be a tiny form before that check where you give the consent. That tiny form, if you read the terms and conditions in that tiny form, it's going to tell you that we are using this data for collecting for our internal purposes and to provide you maybe better services or deals and discounts when you've downloaded this particular mobile app or using this particular website, and we are going to retain it and of course comply within the provisions of this law. For example, you've already downloaded this application and you've given in your email ID or mobile number, and tomorrow you decide you want to withdraw it, you are not happy with the services, or maybe you just don't want to share it for whatever XYZ reason, because probably you're getting too many telemarketing calls. So you can withdraw that consent. In fact, you can even withdraw these consents with the banks. So today we are giving all our data to banks every time we are downloading any app or we are doing any net banking, or in fact, even when we are searching insurances online, the telemarketing marketing people from the banks are calling us left, right, center. So this bill definitely covers that, and this bill would bring the protection to you, that you would stop getting those unnecessary calls. The banks, these agencies would have to tell you upfront why they are retaining it, this information, why are they collecting it and why are they retaining it. And tomorrow, if you start getting bothered, you could withdraw this consent easily. So you can keep using the services and withdraw your consent that you don't wish to share your data with them anymore.
Thanks, Yati. I'm moving on to the other parts of the question. So one is, can you just highlight few of the exemptions which has been provided in terms of number of users or turnovers, so that it can benefit the MSMEs, basically? How?
Yes, of course. Unfortunately, we don't have that exact number as of now. There seems that this would probably come as part of rules and regulations, maybe, or as part of some clarification on this bill. With the current structure of this bill, when I'm looking at the current present structure of this bill, unfortunately, this does not tell us what is the exact number, what is the volume, what is the number of employees that an entity has when these exemptions would apply. However, we just know that these exemptions are going to apply on smaller organizations and MSMEs, but we just have to wait and see what that number is going to be.
Okay, thanks, Khyati. And I hope that number is more practical and somehow save the challenges that might be faced by specifically MSMEs in this matter.
Of course.
In this
I mean,
process,
I'd like to just add one more thing. So a few
Yes,
months
please.
ago, in fact, till your June this month, till the beginning of June this month, the government was still accepting recommendations from the stakeholders, asking them to give in their feedback with respect to the numbers as to what that volume and what that number should be. So, I mean, the government is still deliberating what that number is going to be, where the exemptions are going to apply. So let's wait and watch once those recommendations go in and they come out with a number.
Sure. So, Khyati, we have a next question that is there any qualification for a data protection officer?
Right. Under the current framework, unfortunately, it doesn't tell you who the data protection officer is going to be. There's no qualification given because that is a responsibility on the data fiduciary to appoint one. But of course, it's going to be somebody from the technical background who understands the know-how of how the data is collected, how it's going to be retained, and how it's going to be processed. So at least for that purpose, it's going to be somebody from a technical background.
Sure. So next question is that is ISO 27701 also abbreviated as PIMS in India affected by this bill?
I'm sorry, could you repeat that question, please? I couldn't hear you.
Is ISO 27701 also abbreviated as PIMS?
Okay. So I think with respect to this, no, I'm not sure with respect to ISOs, but this is something I could check and I could get back to you on a later date.
So I'll just request this member to please mention their email ID against their queries so that we can respond back. And also before I proceed, I'll request, because I think because of that some practice of Zoom, the members who have joined without registration, their name is not coming, the actual name. So if they want any information or PPTs or recording of this session, please text your email ID in the chat box so that we can respond back to you on this. Khyati, there is also a question from a gentleman who are into manufacturing of these cameras and video cameras, wherein they are able to collect a lot of information. So wherein they are able to collect a lot of information about the movement of the individuals, or they are storing some information about the individuals, specifically Indians, and those information they're storing under some agreement with Government of India from the national protection point of view. Any exemptions or any leverage to them under this bill?
Of course, if any data is collected and retained for national security or for protecting the sovereignty and the integrity of the country, then of course exemptions would apply on them, which is why I said that number of government agencies would be exempt from the application of this bill.
But it will be only government agencies, right? Or the companies accredited by government agencies.
If your particular company is, let's say, working with a government agency and you are their official contractors, then of course those exemptions would be granted to you as well.
Right. But then they have to specifically obtain that. Otherwise, if you are storing a data even for national security and there is a breach, then you may be held liable in a much bigger manner.
Right. True. True.
So there is a question from Mr. Vivekanand Sharma. Is violation of data protection strict liability similar to copyright infringement, wherein lack of knowledge of offense, motive is not a defense?
Exactly. Lack of knowledge and motive is not a defense anywhere.
Okay. So this answers a lot of queries wherein the users have asked that if by some reason the data has been breached, so will the fiduciary will still be responsible? Yes, they continues to be responsible
They
under
continue,
data
see,
protection
which
bill.
is why the bill has come into place, that you can't cry foul saying that, I wasn't aware that we've collected this data. If you've collected the data, you've collected it. If you're retaining it, you're processing it, you have access to that data. Tomorrow it breaches and leaks. Maybe your employee does it or somebody hacks into your system. You can't cry and say that, sorry, we were not aware. That defense is not going to work. No knowledge of offense is not a defense anywhere. So that's not a defense anywhere.
Right. Then there were certain queries, right? What is the age of defining a children?
Anybody below 18 years.
Okay. There's a query from Sachin from Panasonic. Impact assessment, is impact assessment also covered under this new bill as against 22 bill?
Sorry, the impact, your voice
Is
cracked.
there is provision of any impact assessment in the new data protection bill?
Yes, impact assessment also becomes the liability of the data fiduciary. So yes, that is also covered under the new bill.
Okay. There have been a lot of queries from the e-commerce entity perspective. So that wherein there was a query that if we have given a consent to the holding company and they are sharing the data with the other subsidiaries, will this be covered under this act?
Right, so which is why I said that means that you are transferring data from, even though within the same group, but you're transferring the data from one entity to another, one company to another, which is why at the time when you are seeking consent from the data principal, you have to issue that notice. So then there needs to be a disclaimer saying that this is the purpose of the data. We are going to share it internally within our group companies who are going to retain it and process it. And this is the purpose of the collection and this is how it's going to work. So there needs to be a small paragraph informing the data principal at the time when the data principal is giving the consent that you are going to use this data and transfer it within your group companies.
Right. Kadi, there has also been certain queries, right? For example, while we have an operating entity in India, and there are other entities or they're associated or group entities globally, and they are interchanging the information. So say, for example, if an Indian company is sharing the information with a company based out of a US, which is a group company, then still in US, for example, or still the Indian laws will apply or not in that case.
Right, of course, any data that comes into the territory of India, even if that's being collected in United States and coming into India and being stored in India and processed in India, then of course the provisions of Data Protection Act would be applicable. The Data Protection Bill would be applicable. Cross-border data transfer, like I said, the provisions have made it very easier for CBDT to happen. So any data that goes from here to overseas, that would also need to be compliant under this bill, and anything that comes from overseas and is stored or retained or processed in India also needs to be compliant with the provisions of this particular bill.
Right, and like vice versa. For example, if you're
So
sending the data for Indian, it's both ways.
Yes.
Now there is a question again from the employer perspective by a lot of companies which are into manufacturing and they or may not be purely e-commerce entities, but they're any one data which every entity have is the employee data. Now, what is the provision for that in the new bill? Basically, do we need to take care of it as in the same manner like any other data? Because
yes. See, unfortunately, the bill doesn't distinguish between an employee data and a non-employee data. As long as it's any individual's data, including your employee. Basically, when you're hiring somebody, you're gathering their data like their name, their address, their date of birth, their phone numbers, and whatever XYZ information that you're doing as part of your hiring process. That data also needs to be protected and retained in the same manner as your consumers or customers' data, because it is an individual who is the data principal who's providing you this information. Of course, at the time of hiring, you are informing your employees that you're retaining this to do their due diligence and to do their background checks. And maybe the intents and purpose of collecting data from the customer is very different, but it needs to be processed, complied with as per the provisions of this bill. So there's no distinction between an employer and non-employee data.
Okay. Now, in terms of, there was also a question that, does this bill deal with malpractices like phishing or online scam as part of the cybercrime?
No. So this bill would not deal with cyber crimes. Of course, that is covered under your IT protection laws and your IT laws of the country, and of course the criminal laws of the country. But this says that in case of breach, so they have just very widely and vaguely defined that there's a breach. So that breach could be because of phishing and hacking and other scams that happen, which would hold the data fiduciary liable. And because they've not managed to secure the data, but specifically there are no penalties in case under this provision for phishing, if that's what you want to know. So of course there are penalties in case of breach, which I already mentioned is up to 500 crores. But in case there is a phishing or a hacking and there happens to be a leak or a breach of data, then not only provisions under the this bill would be applicable, but of course there would be provisions under the Information Technology Act and the criminal justice system, which would also be applicable.
Okay. So again, when we say there will be penal provisions applicable and they are monetary. So besides the entity, who all can, as an individual or KMPs or other individuals, can be held responsible for that? Is there any officer in default kind of a concept here?
No. So it's actually, there's going to be yes, there will be an officer in default, which is your DPO, the data protection officer, and depending what kind of breach it has been. So if it's a non-compliance, then of course it's data protection officer. In case it's breach of data, then the entity would be liable, including the officer concerned. But like I mentioned, there are no criminal penalties. So of course there's not going to be any imprisonment, but there are going to be financial penalties. So that those financial penalties would fall upon the entity.
Okay. Now there is a question coming up that, there are a lot of, and my request will be that there will be some limitation in time. Keeping in this, we may also plan another session with Khyati, but we'll try to cover 2 more queries now. There is a very interesting question from Richa. What about the data collected from India used outside country by the fiduciary, exempted in that particular country? What is the law applicable to that fiduciary?
I'm sorry, you're just saying you're collecting the data in India and then processing it overseas. Is that the question?
Correct.
Right. So again, the liability remains the same, because you as a data fiduciary, you're not only processing data outside the country, but as at a first instance, you are collecting the data in India. So as long as you're collecting that data in India, you're liable under the provisions of this law.
Okay. I'm just taking this last question. So while there are certain devices, I think can be again linked with your camera side of it. Say, for example, today's, there are a lot of these drones which are there, and they sneak into your personal properties, or they can collect the visuals of your personal property, or people using different cameras. Okay. Maybe for and they're used by personal agencies. Okay. Maybe during fun times and the game plays. Will they also be covered under the same?
See, if they are used by individuals or maybe by children as toys or adults as toys, maybe, because I see a lot of kids these days and adults have their own personal little drone just to play around with. So for that purpose, of course, this would not be applicable, because you would become, you would get exempt. Like I mentioned, that the government still has to come out with where the exemption would be granted on the basis of volume of personal data gathered and the entity involved. But if that data is used for, used by a company or an agency, or even an individual for business purposes, or using that to sell it or use it and to process it, instead of, just for gaming purpose and playing purpose, of course, the compliances would come into place. But like I mentioned, government agencies would be exempt. So if the government agency, let's say that there are military drones in the sky and they're gathering data, so they are exempt under this provision. In fact, your traffic cameras would also be, so your traffic police cameras would also get exempt. So your traffic police would be exempt. As individuals, if you have CCTV cameras at your home and you're collecting data, you're collecting number plates and you're collecting information, digital information of people, that would be exempt.
Thanks, Khyati. And herein we plan to now bring an end to this session. And we are obliged to Khyati for giving reasonable insight and good insight on this. And we would request her to spare some more time in the next session, because we keeping in mind the kind of response that we have got from the users. We'll like to hold one more session with you on this on the topic. Thanks to all the viewers, attendees. Again, we will request you, those who want any of this information PPT, please share it, please have it. My colleague Harsh will send you the contact details of Khyati and our organization for any further queries. Please feel free to connect. And also, we request you send your email IDs for the reason, so that we can dispatch these participation certificates as well.
Thank you, everyone. Thank you for attending the session and thank you for your questions. It was a learning experience for me as well. Thank you. Thank you, Gaurav. Thank you, Harsh. Thank you, Lex Comply.
Thank you.
It was
Thank
lovely
you,
to be here
Khyati.
today.
Thanks to your entire team, Khyati. I'm sure they have made a wonderful presentation, and this have a very comprehensive details, and everything has been detailed in very clearly. Thank you so much.
Thank you so much. Bye-bye.